These are Everett, Isabel, Max. Just let us know when we have a 1 minute warning. Oh. Good morning. Morning. Today is October 17th. And the commission calls to order docket number 55973. Excuse me, City of Cartersville versus Georgia Power Company. May I have the appearances?
Chuck on behalf of Petition.
Thank you.
Steve Hewitson and Matt Daigle on behalf of Georgia Power Company.
Thank you. Well, Mr. Connolly. And no, I'm sorry, sorry. Mr. Hewitson.
Thank you again, Steve Hewitson on behalf of Georgia Power Company. I probably, since there's only 5 of us in this room, I should probably actually introduce my client as well, Natalie Beesman with Georgia Power Company.
Nice to meet you.
All right. I would reserve 5 minutes for rebuttal, if I may. This case, Cartersville versus Georgia Power Company, is a dispute between the city of Cartersville and Georgia Power regarding which party has the lawful right to provide electric service to a warehouse turned manufacturing facility located in Cartersville, Georgia. The facts relevant to these motions today are not in dispute. The premises is located in Georgia Power's territory. There is no dispute that Georgia Power has provided electric service to the premises since construction began in December of 2020. Georgia Power has served the premises with permanent facilities since February 2022, and the initial electric load of the premises after construction was less than 900 kilowatts. In other words, there is no disputing that the premises did not qualify for customer choice when it was completed and began taking permanent electric service from Georgia Power. Rather, Cartersville's entire argument for customer choice relies on a flawed interpretation of the Territorial Act, OCGA 46.3-8B, which is the exception to the grandfather rule within the Territorial Act related to a premises being destroyed or dismantled and not being reconstructed in substantial kind. Under any logical interpretation of the statutory language, Cartersville's argument fails. Although Cartersville claims to dispute some of the operative facts to avoid summary judgment, it is clear from their own filings that they have no basis upon which to dispute those facts. In response to our motion for summary judgment, Cartersville relies on language from Walton EMC versus Georgia Power to argue that mixed questions of law and fact are inappropriate for summary adjudication. That may be the case when material facts related to changes in the premises are in dispute. But as we explained in our reply brief, for purposes of the motion for summary judgment, Georgia Power accepts all facts alleged by petitioner regarding changes to the premises. Because there are no longer any issues of fact to resolve, the case can and should, in our estimation, be decided on summary judgment without the need for an evidentiary hearing. Accepting all the facts alleged by Cartersville in its filings and testimony as true, the record is completely devoid of any evidence that the premises has been destroyed or dismantled. The Walton case defines destroyed as, quote, the complete ruination or tearing down or breaking down of the premises, end quote. It defines dismantled as, quote, something less, which may, for example, be accomplished by substantially taking apart or substantially stripping Cartersville coordinated with Power to install a breaker and voltage regulators. Cartersville installed the transformer. But a utility must first have a lawful right to serve a premises before it can perform the work to serve it. Cartersville is turning that sequence on its head by claiming that the work it did to make the service possible somehow proves it has the right to serve the premises in the first place. That's exactly backwards and should not be rewarded. Although not found in Cartersville briefing or testimony, we did the work ourselves and searched the record for evidence of destruction or dismantlement. In Petitioner's Exhibit 14, which is the 235 pages of construction plans that Cartersville cites to as the conversion plan, there is one single page demolition plan for the premises that amounts to removal of 896 square feet of wall and 4 exterior bay doors. By our calculation, that amounts to about 1% of the premises exterior walls. Even under the most generous definition of destroy or dismantle, there is no way to define the work done at the premises as a destruction or a dismantlement. Certainly, there is no commission precedent under which the facts of this case can support a finding that the premises has been destroyed or dismantled. At bottom, Cartersville has filed a petition seeking the commission's blessing to serve a premises that does not qualify for customer choice. Practically speaking, under Cartersville's interpretation of the Territorial Act, the destroyed or dismantled exception to the grandfather clause would be completely eviscerated of any plain meaning of the words used in that statute. Cartersville would have you rule that merely adding equipment to a premises and increasing its electrical load would suffice to meet the exception to the Territorial Act. They say as much on page 18 of their reply brief, where they discuss the equipment added to the property and then argue that, quote, from these facts alone, the hearing officer could conclude that the premises was substantially taken apart, end quote. But nothing was ever taken apart and no real structural changes were made to the premises. Certainly not substantial changes like the Walton decision requires. For example, consider a distribution warehouse that has been served by the same electric supplier for 10 years running. That warehouse gets purchased by a new owner who decides to use it as a manufacturing facility. So they bring in a bunch of new equipment that uses more electricity than the warehouse did. They had wire, they had conduit, they had transformers, but they didn't make a single change to the building structure. They destroy nothing, they dismantle nothing. Under Cartersville's interpretation of the Territorial Act, they believe that getting a new tenant who expands the premises has created a, quote, new premises that has been, quote, destroyed or dismantled, as that term is used in the Territorial Act. That interpretation stands on its head all commission precedent interpreting this exception to the grandfather clause and can't possibly be the meaning of destroyed or dismantled as intended by the drafters of the statute. It certainly is not supported by the seminal decision in this area of Walton EMC versus Georgia Power. Because the record is devoid of any evidence of destruction or dismantlement, Georgia Power is entitled to summary judgment, and we ask that you rule accordingly. Thank you.
Good morning, Chuck Connolly again for Petitioner City of Cartersville. In their briefing, Georgia Power advances 3 arguments as to why the premises at issue does not qualify for customer choice under the Territorial Act. The first argument is the premises is not new. The second argument is that the connected load at initial full operation of the premises was less than 900 kilowatts. And then the third argument is that the premises does not have single metered service. Now, in the oral argument, I didn't hear a lot of discussion, frankly, about any of those 3. The discussion centered on whether the premises has been destroyed or dismantled and not reconstructed in substantial kind. But just to make sure the record is clear, at least with respect to 2 of the arguments that were advanced by Georgia Power in their briefing, we believe that those arguments were squarely addressed just 9 months ago in the Georgia Supreme Court's decision, Walton EMC. I do want to note for the record that Georgia Power was a party to that case. They were actually the petitioner in that case, and they advanced similar arguments to those that they're advancing in this case, which were not only rejected by the Georgia Supreme Court, but they were also rejected by the hearing officer assigned in that case, as well as the Public Service Commission. Now, for obvious reasons, we have an extensive discussion of Walton EMC in our brief, and I'm not going to repeat that for our purposes today, but let me just summarize. First argument Georgia Power makes is focusing on OCGA section 46-3-8A, is that the premises was not new. Well, that issue was expressly addressed in Walton EMC, and the Georgia Supreme Court said the premises does not have to be new. What the Georgia Supreme Court did was to clarify that OCGA section 46-3-8A is explicitly made subject to subsection B. Therefore, if a premises is destroyed or dismantled and not reconstructed in substantial kind under subsection B, it is treated as a new premises, as that term is understood in subsection A. Now, the second argument Georgia Power advances is that at initial full operation, or for our purposes at least, initial full operation means that when the prior owner first developed the premises as a speculative office warehouse space. And again, our position is, and I'll come back to this in a minute, that Walton EMC also resolves that issue in our favor. So we believe that the central question in this case is whether the premises at issue was destroyed or dismantled and not reconstructed in substantial kind, as those terms are used in the statute. And if it was, at the time of its reconstruction, was the connected load 900 kilowatts or greater? And as the Georgia Supreme Court said in Walton, this type of mixed question requires a nuanced case-by-case characterization, assessment of, or judgment of whether the given historical facts are properly characterized as meeting the legal standard, and summary adjudication is typically not appropriate in these cases. And then there's the third issue that I didn't hear Mr. Hewitson address in oral argument, that is the single metered service issue, and I will spend a few minutes on that. We do respond in our brief to their statement of undisputed material facts. We also list about 17 enumerated additional facts that we think are material in this case. We also set forth the summary judgment standard, and again, a lengthy discussion of Walton EMC, which in the interest of time, I won't go through here. But let me go back to the initial question or the initial argument made by Georgia Power for just a minute. The question is not, in this case, whether the premises is new. Again, as the Walton Court articulated, the question in this case is whether the premises was destroyed or dismantled and not reconstructed in substantial kind. If it is, then it is treated as new under the territorial act. And again, we think the record, if the record establishes that a new customer, in this case Accor, destroyed or dismantled the premises and did not reconstruct it in substantial kind, it doesn't matter whether the premises was new. They rely on Jackson EMC as support for that argument. Jackson EMC is distinguishable from this case. It didn't even involve the same issue. In that case, the issue was whether the same customer, a church, who had previously elected Georgia Power as its electric service provider, could then change its mind and choose a different electric service provider. It didn't have anything to do with whether a premises had been destroyed or dismantled, not reconstructed in substantial kind. It really turned on the question of whether the customer choice in that case constituted a binding contract. And that's not the issue in our case. As to the second issue, and that is whether the premises had a connected load of 900 kilowatts at initial operation, the argument Georgia Power advances is that for that purpose, initial operation meant when the prior owner developed the property for office warehouse, speculative office warehouse, and not when Accor transformed the facility into an actual manufacturing facility. Now, the Georgia Court of Appeals has recognized that the terms connected load and initial full operation, as defined in the Territorial Act, are not defined in the territorial. Again, Georgia Power argues that initial full operation means when the former owner first operated the premises as an office and warehouse or developed it as an office and warehouse. I will say respectfully that the record does not reflect that Hines ever actually operated the premises as an office warehouse. In fact, our position is the record reflects just the opposite. The premises was constructed as speculative office warehouse distribution space. But before it was ever used as such, Act 4 discovered the premises through a broker and then converted the premises to an actual manufacturing facility. Now, even if it had been operated, Georgia Power's argument is once again, in our view, controlled and foreclosed by Walton EMC. If Georgia Power was correct in Walton EMC, the relevant inquiry would have been what was the initial, what was the connected load when the premises was first operated as a textile mill decades earlier, not as the Supreme Court determined, which was after the facility had been converted from a textile mill to an actual pet food manufacturing facility. It is the point at which the premises has been destroyed or dismantled and not reconstructed in substantial kind that is the initial operation for our purposes. And I think that that is pretty clearly set forth in the Walton case. In our case, there's not even a contest, we don't think, as to whether when Act 4 started operating the premises, the connected load was 900 kilowatts or greater. Again, they're trying to move the goalpost back to when the property was initially developed for speculative office and warehouse space, and that is not the relevant inquiry under the Walton case. Let me get to then the sort of the central issue, which is whether the premises was destroyed or dismantled and not reconstructed in substantial time. And again, I want to emphasize the Walton court says that this is a mixed question, law and fact, that requires a nuanced case-by-case characterization, assessment, or judgment, and is typically not subject to summary adjudication. Now, that said, the Georgia Supreme Court spent a good bit of time talking about what destroyed or dismantled, reconstructed, and substantial kind mean under the statute. And I do think what the Supreme Court said in that regard is important. So here's what the court said. We conclude that destroyed refers to the complete ruination or tearing down or breaking down of the premises, while dismantled means something less, which may, for example, be accomplished by substantially taking apart or substantially stripping away a building's structural components, furniture, equipment, or other significant contents without the added requirement of entire destruction. Court went on to say, we hold therefore that the Court of Appeals erred in interpreting destroyed or dismantled to require the premises to be taken apart, disassembled, or ruined in holistic rather than partial manner. Went on to talk then about reconstructed in substantial kind. Court said, we have no trouble concluding, nor do the parties disagree, that reconstructed in substantial kind means reconstructed premises that are largely, but not wholly, of the same fundamental nature or quality as they were previously. Accordingly, taken together, we construe the phrase destroyed or dismantled, in which are reconstructed in substantial kind, as extending an electric supplier's exclusive right to continue serving the premises if, among other things, the premises are completely ruined or torn or broken down, or short of entire destruction, the premises are substantially taken apart, or the premises structural components, furniture, equipment, or other significant contents are substantially stripped away, and the premises are constructed again largely, but not wholly, of the same fundamental nature or quality as they were previously. That's how the Walton Court articulated. So let me turn to the facts of this case. Again, the premises at issue was constructed as a speculative office warehouse distribution facility in the 2021-2022 time. But before it was ever operated as such, Act4, the tenant, the customer, discovered the premises in March of 2023 through a broker. Act4 then converted the premises to an actual manufacturing facility, primarily to manufacture aluminum cable tray. The conversion of the premises to a manufacturing facility involved a set of construction plans consisting of 235 pages. Those plans are in the record of this case. The cost of the conversion to Hines, the previous owner, was round numbers, $4.5 million. The cost to Act4, the tenant, the customer, was $2 million, which included considerable investment in the electrical infrastructure inside the facility to meet the needs of Act4. Testimony in the record of this case. From an electrical, among other things, Act4 had to upgrade their switchgear and pull additional secondary wire to each transformer. From an electrical power standpoint, premises as initially constructed by Hines was served by a 300 kVA transformer. However, load tests showed that Act4's electrical power needs would be 1.5 megahertz, requiring a 1500 kVA transformer, or a transformer 5 times the size of that initially serving the premises. In order to extend service to the premises, Cartersville had to acquire a substation breaker and design and build three-phase service to the premises. In fact, Cartersville provided 14,500 feet of three-phase service to the premises. Cartersville coordinated with MEAG Power to install a breaker and voltage regulators in the substation to support the increased load. Cartersville performed the overhead line work, installing approximately 3,000 feet of overhead primary wire. They contracted with crews to install around 12,390 feet of underground primary conduit. They installed another 500 kVA transformer to the rear of the property to also serve Act4's electrical needs. So Cartersville spent $600,000 to extend electric power to the premises. So between the original owner, Act4, and Cartersville, $7 million was spent in the conversion of this facility from speculative office warehouse space to an actual manufacturing facility. Our position is these facts alone would allow the hearing officer to conclude that the premises was substantially taken apart, that the premises structural components, furniture, equipment, and other significant contents were substantially stripped away, such that the premises was dismantled as the Walton EMC court instructs. We also think that the hearing officer could conclude that the reconstruction of the premises was not of the same fundamental nature or quality as was there previously, which again, the Walton court instructs. At a minimum, we believe that summary adjudication as to these issues is not appropriate. Real quickly, again, although it wasn't addressed in opening argument, I want to talk about the single metered service issue just because it's part of their basis for moving for summary judgment.
You have about 4 minutes.
Okay, I won't need that, I don't think. As it relates to single metered service, it appears that Georgia Power's argument is simply this, that the premises is being served through 4 separate meters, separately metering the electric service to the premise. And according to Georgia Power, that ipso facto means that there can't be single metered service. But they don't cite a single Georgia case where the courts have determined that having more than one meter necessarily means that the single metered service requirement isn't met. And in fact, the Georgia Court of Appeals has said just the opposite. We cite the Central Georgia EMC case in our brief. Georgia Court of Appeals says the commission has consistently refused to rely on the number of meters as the single dividing factor in decided cases under the grandfather clause in the territorial act. In Central Georgia EMC, the issue was whether a new gym that was constructed on the same campus as a high school but was separately metered, was nevertheless part of the same premises of the high school. And the Court of Appeals again said whether there's 1 meter or more than 1 meters is not dispositive. Rather, you have to examine other factors. Is there a common electrical system for the existing buildings? Is there a power bill that's sent to the same customer? And is it paid by the same customer? So there are other things you need to look at in the case in order to determine whether the single metered requirement is met other than just the number of meters. We similarly cite PSC decision, Georgia Power Company versus Carroll EMC, where again, the number of meters was not dispositive, even though there were separate meters in those cases. Commission determined single meter requirement was met. We cite a case by the Georgia Supreme Court, which again, at least confirms that having more than 1 meter is not dispositive. In our case, we have one building occupied by one customer. There are no other tenants in the premises other than Accor. And while there are 4 separate meters at the premises, they serve the same building, they serve the same customer, a bill is sent to the same customer, and a single customer pays the bill. And again, our position is those facts are sufficient to satisfy the single metered service requirement under the territorial.
Just briefly on the single metered single meter service issue. I did not focus on that primarily because I think our pleadings on that issue are very clear. Also, that is an issue that is only reached if the hearing officer determines that the property has been dismantled or destroyed or dismantled and not reconstructed in substantial kind. And I do not believe the facts of this case lead to that. I think summary judgment is granted before you even reach that. But we had that in our pleadings or in our briefing for completeness sake. We also, in our motion for summary judgment, went through the requirements under Georgia law to establish that Georgia Power has a right to serve the premises so that it established the grandfather clause. And that is why the initial arguments in the briefing were included. My discussion earlier today focused on Cartersville's response brief and their arguments that they qualify for the destroyed and dismantled exception, which is why I focused there. The facts of this case are vastly different than the facts of the case in Walton versus Georgia Power EMC. Mr. Connerly cites to 17 additional facts in the brief, but those facts don't support the exception to the grandfather rule. I went through the 5 facts of those 17 that have anything to do with changes to the property. They are all additive with the exception of one, which was to replace some of the wiring and the conduit within the facility. Everything else was additive to the property and everything else was outside of the premises itself. One point that Mr. Connerly makes is that Hines never actually operated the property. He argues that initial full operation of the premises should be when Accor took over the property from Hines. But the record in this case establishes that the premises was built and fully operational as originally designed as a warehouse in April of 2022 at the latest. And you can find that in the record at Petitioner's Exhibit P23, which is a certificate of completion for the premises dated April 21, 2022. So the property was completed. Georgia Power was the service provider, and Georgia Power was providing service to the property. The grandfather clause was established, or the service to the rightful, the right to serve the property premises was established when that happened, and Georgia Power was the lawful provider of the service. While I understand that Cartersville argues that the premises became new under the Territorial Act when Accor moved in, the record in this proceeding only establishes that Accor expanded the facility. It did not destroy or dismantle the facility. And I would cite you to the Douglas County EMC versus Georgia Power Company decision, where the commission explained that the adopted definition of initial full operation of the premises, quote, should not be construed to mean that if a consumer has plans for future growth or hopes to expand its facilities in the future such that the expanded facilities would result in a connected load of 900 kW or greater, that the facility would qualify under the exception set forth in OCGA section 46 3-8 subpart A. It is directly on point. What what Cartersville is attempting to establish in this proceeding is that they have added to the property and they have expanded the property to be a manufacturing facility rather than a warehouse. But all of their evidence, everything in the briefing, all of their pre-filed testimony and the exhibits establish that they added facilities, most of them outside of the property. I will make note that the 235-page construction plan that Mr. Connor cites to is actually about 4 copies of the construction plan. If you look at unique pages, it's about 70 some pages of the construction plan. But again, as I said earlier, if you look for what has been destroyed or dismantled, there is a 1-page demolition plan in there that shows 896 square feet of the property being demolished. That's about 1% of the exterior walls. In Walton, in that case, the hearing officer and the Georgia Supreme Court went through great lengths to describe the changes of property, the substantial physical changes to the property in great detail to establish that it was destroyed and dismantled. They talked about how much was changed, how much was spent, and how the property was completely different, substantially different than it had been prior to the work done on it. Here, what you have is you have a spec warehouse, I guess, that was built, completed, and served by Georgia Power. A new owner comes in and installs new equipment, does not destroy anything, does not dismantle anything, and then establishes facilities outside of the premises, the wiring, the overhead line, the underground conduit line, and argues that that means the premises has been destroyed and dismantled. That would stand the precedent of this commission on its head and would completely eviscerate the Territorial Act and its exceptions. Unless there are any questions, that's all I have.
Thank you very much, gentlemen.
Thank you. Do you want to just roll right into the next?
I think
Motion.
so. Y'all want a break or anything?
I'm fine.
That's just bad.
Okay. The next motion is Georgia Power's objections to pre-filed direct testimony. I can't imagine that I'm going to need to reserve 5 minutes for rebuttal, but I will anyway, just as a formality to make sure. Georgia Power has moved to strike portions of the pre-filed rebuttal testimony of Robert Benjamin Butcher for offering improper legal conclusions and unqualified expert opinions. Specifically, there are 2 sections of Mr. Butcher's testimony that Georgia Power objects to. It's page 3, lines 19 to 21, which states, quote, "But so long as those meters are serving the same premises and are billed to the same customer, that would still be considered, quote, single metered service, end quote, under the territorial." The second section is page 5, line 16 through page 6, line 1, where the question is, and based on your review of these documents and the other documents you mentioned earlier, what is your testimony as to the connected load at the ECFOR facility at the time of initial full operation of the premises? The answer, that it easily exceeded 900 kilowatts. These sections seek to provide testimony containing inadmissible legal conclusions regarding whether the legal requirements for single metered service and initial full operation are met as required by the Territorial Act to establish eligibility for the large load exception. Witness Butcher is not a lawyer. He has not been qualified as an expert witness to offer these opinions, and they should be stricken. In Georgia Power Company versus Carroll EMC, the commission explained that the phrase initial full operation is a term of art and determinations of such are legal conclusions left to the sound discretion of the commission. Specifically, the commission noted that, quote, reliance on expert opinion to determine the existence or date of initial full operation would constitute an abdication by the commission of its duties as trier of fact. Witness Butcher is not an attorney and has not been qualified as an expert to undertake load counts. His legal conclusion regarding when initial full operation occurred and whether the connected load satisfies the 900 kW threshold within the Territorial Act falls squarely within the purview of the commission and you as the hearing officer and should be rejected. Similarly, Witness Butcher's testimony that the premises would be considered as receiving single metered service under the Territorial Act is a legal conclusion regarding the satisfaction of the single metered service requirement of the Territorial Act's large load exception. His testimony that service to the premises being billed to one customer satisfies the legal requirement for single metered service offers a legal interpretation of whether the facts of this case satisfy this prong of the requirement or customer choice. That determination is for the commission to make based on your review of the facts in this case. It is a legal conclusion and should be rejected. We'll make one note about this motion. This motion is a prophylactic motion if we get to a full hearing. None of the facts, none of the evidence that I'm speaking about in Mr. Butcher's testimony goes to whether Cartersville's changes to the property or Accor's expansion of the facility destroys or dismantles the facility. So none of Mr. Butcher's testimony is relevant to this motion for summary judgment. They're completely separate, and you only have to reach them if you rule that that summary judgment is not proper in Georgia Power's favor. Thank you.
Thank you.
As I understand their motion or their objection at least, I don't believe that Georgia Power objects to most of what is contained in Mr. Butcher's pre-filed testimony. By way of example, he talks about his experience. In his experience, it's not uncommon for a large facility like the Accor facility to have multiple meters, especially when there are multiple service points at the facility. He offered testimony that sometimes the electric supplier to the facility will even suggest or require multiple meters. There's testimony distinguishing between connected load versus peak usage, and the fact that those two things are not the same. And again, my understanding is Georgia Power does not object to those portions of Mr. Butcher's testimony. What it objects to are two specific statements, and that is that the premises has single metered service and that the connected load at the time of initial operation of the premises exceeded 900 kilowatts. Now, as to the second issue, at least in reading their objection, as I understood it, it was a relevance objection, because what they said was, again, you don't look at the initial operation at Accor's when they started operating. Rather, the relevant inquiry is when Hines built it as spec office space. And because Mr. Butcher didn't look at that issue, but instead looked at what was the connected load when Accor reconstructed the facility, that their objection was based on relevance. So I would submit to the hearing officer that if you determine, as the Walton EMC court instructs, that the relevant inquiry is when Accor reconstructed the facility, not when it was originally constructed. And again, I want to emphasize the facts. And in Walton, that facility in Walton had been operated for decades as a textile mill. It was converted to a pet food manufacturing facility. The inquiry was not what was the connected load when it was initially built as a textile facility. The relevant inquiry is when it was converted to a pet food manufacturing facility. So again, my understanding at least was that their objection on that point was a relevance objection. Now, as to the second issue, which I should say the first issue, which is single metered service, I just note that Mr. Butcher is a professional engineer. He has been for nearly 15 years. He has more than 20 years of experience in electric utilities business. He is the Senior Director of Engineering and Energy Services for the Electric Cities of Georgia. As such, he is responsible for engineering and pole attachment services along with customer choice and territorial decisions. He could pretty clearly be established as an expert witness in this matter, but even if he wasn't, Georgia law clearly allows lay witnesses to offer opinion testimony. The bigger point is this is not a jury trial. Ultimately, the hearing officer will determine whether the premises has single metered service as that set forth in the statute, and whether the connected load at the time of initial full operations exceeded 900 kilowatts. And in making that determination, you can rely or you will rely on the testimony and evidence presented. And in the case of opinion testimony, you can give it as much or as little weight as you want to assign to it. So our position is there's no reason to exclude the testimony. Ultimately, you will make those determinations, and again, you'll give that testimony as much weight as you see fit.
Not much to rebut there. I will note that I understand that Mr. Boucher might be someone who could be qualified to give load count testimony, but he was not in this proceeding, and it was not established in his direct testimony. So it is improper expert opinion for him to provide. Also, his testimony regarding what constitutes single metered electric service under the Territorial Act would be a legal conclusion that would be improper. Of course, as Mr. Connerly said, this is before a hearing officer, and you can make those determinations, and you will make those determinations if we get to that point. Also, there is evidence in the record that Atcor's connected load was expected to be greater than 900 kW after their expansion of the facility. We don't dispute that that's in there. What we're disputing is who gets to make those statements and upon what evidence, and that's why the motion was filed. Thank you.
Thank you.
I think we're on now my motion for leave to file supplemental refile direct testimony. So if you look at our original pre-file direct testimony, it included both testimony and two actual load studies that demonstrated that Atcor's electric power needs would be 1.5 megawatts. Now, we had assumed based on that we would be able to stipulate that at least Atcor's electric use at the time of initial operation is 900 kilowatts or more. I understand the legal argument that Georgia Power is making, which is that's not the relevant inquiry. The relevant inquiry is when Hines built the spec office space. But at least today, we've not gotten a stipulation that at Atcor's initial operations, the connected load was 900 kilowatts, despite the fact that we've got testimony and two load studies in the record to that effect. So just out of abundance of caution and belt and suspenders, I sent an expert witness out to the Atcor facility to actually look at the faceplates on the equipment out there and to do what would now be a third load study. And so our request is to allow us to file supplemental pre-file direct testimony to include that, again, just out of abundance of caution. It's moot if we can agree that at least at Atcor's initial operations, the connected load was 900 kilowatts or more. If we can't, then we'd like to present that testimony. I would submit to the hearing officer that we sent that load study to Mr. Hewitson in August. They've had several months now to look at it. There's no prejudice to them if that testimony is allowed. They're welcome. If they really intend to contest it, they're welcome to go out and get an expert, go look at the faceplates and make their own determination. So there's no prejudice to them, and it's not going to delay, the proceedings in this matter. We're here at the summary judgment stage. If there's at least currently no final evidentiary hearing scheduled. So our position is that there's no harm in allowing this testimony.
Thank you.
Yeah, and Mr. Connerly, I guess hits the nail on the head to a certain extent. I mean, Georgia Power understands that Cartersville has introduced other load count studies or other load studies of the premises dated from May of 2023 and August 2023, showing above 900 kW for a load count for Atcor. The point that we are making also goes back to the motion for summary judgment that the term connected load at initial for full operation has specific meaning under the Territorial Act. It means the load to be furnished to the customer at the time the customer commences full operation of the facility as designed. The Territorial Act defines premises as the building, structure, or facility to which electricity is being or is to be furnished. It is not dependent on the specific customer occupying the premises, but rather the premises itself. Once established, the connected load of the premises for purposes of the Territorial Act does not change. Unless the premises is destroyed or dismantled, which goes back to the motion for summary judgment, the premises cannot claim customer choice under the large load exception. Cartersville is conflating connected load at the time of initial full operation of the premises with the load of a new tenant when it begins operating at an existing premises. A new customer occupying the premises cannot simply undertake a new load count and create customer choice. That's not what the Territorial Act is meant for, and that's not what the grandfather clause or the exceptions to it are meant for. That is what Cartersville motion seeks to interject into the record. And the proper testimony of it is the proper testimony of a load count undertaken in July of 2025. But as I said before, the record in this case establishes that the premises was built and fully operational as originally designed in April of 2022 at the latest. So a load count undertaken more than 3 years after the premises reached full operation is irrelevant to the proceeding. And again, I understand that Cartersville argues that the premises became new under the Territorial Act under their interpretation of destroyed and dismantled, but the record only establishes that Accor expanded the facility, did not destroy or dismantle the facility. And as we explained in our objection, this commission has already determined that plans for future expansions of the premises do not qualify the premises for the large load exception. And that is cited to you earlier, the Douglas County EMC versus Georgia Power Company case, which is docket number 3686 in 1988 from this decision, from this commission. Because the record only establishes that Accor expanded the facility, did not destroy or dismantle it, the initial full operation of the premises occurred in 2022, not July of 2025, and that load count at that time is irrelevant. Thank you very much.
Right. Yeah, really back to sum up. I'm gonna go ahead and rule on these, and my reasoning and will be included in the final order of this case. After we have here, I am denying George Power's motion for summary judgment. We're denying Georgia Power's objections to testimony. Portions of pre-trial testimony. There's several reasons why there, and I'm granting the ability to motion to leave to file supplemental testimony on behalf of City of Cartersville. Mr. Hewitt said I also will give you the opportunity to file supplemental testimony if you so need to. Would like to. So we will go forward with the hearing. And when I get back to my office, I will email you some potential dates. And you can look at those, check with your witnesses, so forth. See how your calendars look. And is there anything else?
No, I take it there will be, well, did you say that you were going to issue a written opinion on the denial of the motion for summary judgment?
I'm gonna fold that into the final order.
Can we get a better understanding of what it is you think is left to be heard at an evidentiary hearing, since the facts related to the exception are not in dispute?
Say that again.
Yeah, can I get a little bit, it would be helpful going into a hearing if I understood your view of what facts are in dispute.
That's all facts. I mean, in terms of summary judgment, there are several issues, genuine issues of material facts. And so there are, I mean, that the testament will go forward as it's filed.
Okay, but there aren't specific facts that would help us to focus what the presentation at the hearings.
No, done. I think they're all the facts and discussed here today are facts that need to be sworn, have sworn testimony.
Right, but those are facts that nobody has disputed. That's my question is, well, as I said at the beginning, at the outset, for purposes of the motion, the changes that Accor has made to the facility, the additional wire outside of the facility, none of that is in dispute. We don't dispute that happened. The question is whether it qualifies for the Territorial Act exception of destroy and dismantle. So trying to get a better understanding, help focus at the hearing, what facts we should have, because the hearing should be to establish the facts, but if we agree that those are the facts, I'm having a little bit of difficulty, and maybe I just need to go back to the office and think about it a little bit more, and a little bit of difficulty of what presentation of evidence you wanted to see.
You have, both of you have listed, undisputed facts.
Yes.
And there's big difference. You know what you stipulate. And so any undisputed fact that is not clearly stipulated or well, you don't have to stipulate. It seems that the issues that are disputed are clear from what you do not agree with. You would not stipulate the fact that it's $900.
No,
Or that it's even available because of sure.
well, right.
Right.
But I also noted that we don't dispute that Cartersville already has in the record 2 load counts from 2023 that establish Accor's expected use of the property is over 900 kW. So that fact's not an issue.
That's an issue. As to when you're timing for looking at the initial full operation.
Okay.
I think that's clearly. Admit that. Whether this is a customer choice, an exception to grandfather clause is an issue.
But that's a legal determination to be made by the commission.
Oh, I see.
Yeah.
Can I offer a suggestion?
Yeah.
I mean, you're, as the hearing officer, you're within your rights to just deny the motion for summary judgment and have each side present their case in the hearing. And that's what I understand the hearing officer determination to be. You're not further obligated to go through and itemize a list of what you contend to be disputed facts. Just simply say, I'm denying the motion for summary judgment. Let's get a hearing date. Each side present their case, and then I'll make a decision based on the evidence that's presented.
I like that.
Okay.
Thank you. You taking nothing right now. I know you're not tickled with that.
Well, it's not that I'm not tickled with it. The decision is yours to make. It is confusing to me if the facts are not in dispute. What do you want to hear here? But again, maybe I just need to go back and sit down and figure out what it is. Maybe I can listen or read the transcript of this and understand a little better.
Me too. So we may revisit this, but at this point, I'm gonna offer some options for the actual hearing.
Sure. Thank you.
Thank you so much. That was,